So we are being live streamed now. Thank you. All right. Good afternoon. This is Senator Nick Charles for the record, and I'm bringing the task force to study fiduciary adjudication in Maryland task force meeting to order. We have for the day October 27, 2025, and it is now 6:01. We're meeting via Zoom. Uh, our agenda for the day is going to start with my opening remarks. Then we're going to go into a brief introduction and overview, the qualification, selection, and training of judges, hearing probate and other fiduciary matters in Maryland. And then we'll go into a brief introduction into jurisdictional statutes. And then we'll go through the following agenda items, examining the jurisdiction of the Orphans Court and Circuit Courts with respect to fiduciary duties. Then we'll compare the jurisdictions of probate court and other states. And then we will conclude with remarks from myself as chair. We have a few more meetings to go, up all the way until December. So we're going to be moving at a pretty fast pace to get as much information out as possible so that we can get this report done and bring it back to the Maryland General Assembly. So I'm going to go ahead and start us off with Holly Vandergrift from DLS and with Jonathan Lastly from the Maryland State Bar Association to walk through section 2 of our agenda. And just for other purposes as well, as we move forward, just for some housekeeping tips for all members, please utilize the hand raising function so that as we're talking, you're not over talking somebody, because I don't want this to get into a passionate debate without at least giving every side to have a piece to talk about. So thank you so much.
Thank you, Chair. Good evening, task force members. So since our first meeting last Monday, there have been some questions from members in the public, and we thought we would provide just a very brief summary and overview of Maryland's orphans courts to particularly help the members on the task force who are not experts in the field in the general public. So the topic of the qualifications, training, and selection of orphans court judges, this is really going to be talked about at our November 10th meeting of the task force. This, again, is just going to be a short summary just to provide a little bit of background to help with discussion purposes moving forward. So the material that you want to look at for today, it's going to be titled Brief Overview. So if you're looking at the website, Brief Overview, Maryland's Orphans Court Judges, Qualifications, Training, and Selection. And it's broken down into 4 parts. The first part just provides a little history of the Orphans Court. Again, this is to answer some of the questions that came up since our first meeting. So orphans courts were established in 1777. They were created in each county and served by a register of wills, and the judges then were appointed by the governor. The 1851 Constitution made orphans court judges constitutional officers, and then during the 1867 Constitutional Convention, the delegates debated abolishing the orphans court, but ultimately chose to retain and reform it, mandating the election of 3 judges in each county and in Baltimore City. And this structure largely remains today across jurisdictions in the state. The materials also have links to the web pages, so you can read more if you want more background on it. Present constitutional recognition of the Orphans Court can be found in Article 4, Sections 1 and 40 of the Maryland Constitution. Judges of the Orphans Court exercise limited jurisdiction and are charged with Estates and Trusts Article Section 2102. Joe is going to be discussing this jurisdictional statutes materials next, so I'm going to leave that up to her. And then finally, we talked about this at our last meeting, but at the request of an interested person, any issue of fact arising in the Orphans Court may be transferred to the Circuit Court for trial. The next part of the paper says, basically talks about jurisdictions, and there were some questions about this. There are 24 jurisdictions in Maryland, 23 counties in Baltimore City. 18 jurisdictions in the state have 3 elected orphans court judges who are not required to be attorneys, but they can be attorneys. and generally require 2 to 3 judges to sit together as a panel when hearing cases in those jurisdictions. 3 jurisdictions in Maryland, Baltimore City, Baltimore County, and Prince George's County, require judges to be members of the Maryland Bar and attorneys in good standing. And in these counties, you can also, a single judge may preside individually over cases. Then you have the 3 jurisdictions, Montgomery County, Harford County, and Howard County, that have no separate orphans courts, and instead the circuit court judges sit as the orphans court judges in those counties. Again, there are a lot of details here and specifics of when a single judge can sit or 2 to 3 judges. MSBA is going to get into all of that at our November 10th meeting, but we just wanted to break these jurisdictions down to give some context into the 3 categories. The next part is orphans court judges. They are elected to 4-year terms during the general election. Under the Maryland Constitution, orphans court judges must be at least 18 years old, be a citizen of Maryland, and have resided in their jurisdiction for at least 12 months prior to the election. There's no minimum education requirements except in Baltimore City, Baltimore County, and Prince George's, which requires judges to be members of the Maryland Bar and in good standing. And then finally, the last part is just a little bit about training, because we had a couple questions about that. The registers are going to be talking about this at length. They've done a lot of research on this, and that again will be at the November 10th meeting, but these are some big parts. There's no formal education no formal education is required prior to serving as an orphans court judge. Again, unless you're in one of those 3 counties that requires the judges to be an attorney. Currently, new orphans court judges must complete a 3-phase orientation process before being sworn in, and it includes an introductory meetings, bench training, and participation in a formal orientation program. The judicial training and continuing education are governed by an administrative order that was recently issued. It's dated September 10th, 2025, and entitled Conference of Orphans Court Judges and Education for Orphans Court Judges. And there's a link in the materials if you want to read it. And then that order establishes additional training, orientation sessions, and annual continuing education requirements for all orphans court judges starting in 2026 and in 2027. So this is just a brief background. Hopefully it'll answer some questions. John, is there anything that you'd like to add before we move forward to the next piece?
Not at all. I think you've done great, Holly. Happy to answer any questions, but yeah.
Thank you. Thank you for your help pulling all this together. And I'm not sure, Chair Charles, if you'd want to take a couple questions, but we don't have much time on this. We have the main topic of today is the jurisdictions of the orphans court and circuit courts. This was just a little bit of background.
Yeah, and I appreciate that, but I will just entertain any comments or questions before we move forward. All right, so we can move on to the next section.
Okay, thank you, Chair. Good evening. My name is Joe Tatlow. I'm with the Department of Legislative Services, and I want to share my screen. Let's see. Can everyone see that piece of paper? Jurisdiction. Okay.
Yes.
I just looked at some of this is a reference document for you, and I hope it is substantially complete. What the States and Trusts article and some other statutes specify about the jurisdiction of the orphans court and the circuit court. The jurisdiction, the orphans courts are courts of limited jurisdiction, authorized to conduct judicial probate, direct the conduct of a personal representative, some witnesses, and issue orders. There's a couple times in the States and Trusts article that this sentence appears, specifying in the orphans courts under pretext of its incidental power, constructive authority may not exercise any jurisdiction. They only can exercise jurisdiction if it's expressly conferred. There's no implicit jurisdiction with the orphans court. So a court of limited jurisdiction is the orphans court. The jurisdiction of the circuit courts or courts, they're trial courts of general jurisdiction with equitable powers in the state. And I indicate here that the circuit court has jurisdiction over trusts and fiduciary matters. It has personal jurisdiction over a trustee, a beneficiary, or a distributee of a trust. The circuit court may intervene in the administration of a trust, fashion a remedy for a breach of trust by a fiduciary, and also remove a fiduciary or a trustee. So the Orphans Court handles contested wills, maybe is a shorthand way to say it, and the circuit courts handle trust and fiduciary matters. With respect to guardianship of the person and the property of a minor, there's concurrent jurisdiction. Now, the Orphans Court does not have jurisdiction over the guardian of the person and property of a disabled adult. But with respect to a minor, there is concurrent jurisdiction over both guardian of the person and guardian of the property. So I have the statutory references there. There are some references that just refer to the Orphans Court. And so I have these here under guardian of the person. And this is all in Title 13 of the States and Trusts article, that the Orphans Court may exercise guardianship of the person over a minor, even if the minor is not inheriting property, if the presiding judge of that Orphans Court is a member of the bar. Another provision indicates that that matter can be transferred to the circuit court if it's in the best interest of the child. And in another provision, 13702, the Orphans Court may appoint a guardian of the person, and I'm not going to read all this, but this is the evidentiary standard that's required in order for that to happen. And the parents have to consent, and the parents don't want to be the guardian of the minor. So these are just some other references in the States and Trusts article to guardian of the person with respect to the Orphans Court. Now, the circuit court has even additional jurisdiction over the guardianship of the person and the minor outside of the Estates and Trusts article. There's both in the family law article and the courts and judicial proceedings article. The circuit court has exclusive original jurisdiction over certain juvenile causes, which includes guardianship. The circuit court is the equity court with jurisdiction over certain specified subjects in the family law article, which includes guardianship, and then also with respect to crimes. And I cite this attorney general opinion in this case because both of these are illuminating regarding the difference between the circuit court and the Orphans Court for guardian of the person of a minor. So I leave that to your reference. And then finally, again, guardian of the property, they both have concurrent jurisdiction. And this is just another statutory reference to that. And of course, if the minor is entitled to property, then a guardian of the property needs to be appointed for that minor. And there's one specific reference to the Orphans Court, just indicating that if the Orphans Court has jurisdiction over a minor's estate that's being handled by a guardian. So I didn't talk about powers of attorney or advanced directives, but financial power of attorney and advanced directives, which is the healthcare document, but the circuit courts have jurisdiction over that. If you'd like me to put that on it, write those statutory references down, I'd be happy to. And thank you very much.
All right, I see Delegate Kaufman has his hand up, followed by Delegate Sandy Bartlett.
Yes, thank you. And this is just an item for I would appreciate a discussion of this at a future meeting. I am born and raised in Montgomery County, and I've lived in Montgomery County my whole life. And the functions of the Orphans Court are handled by um, by the Circuit Court. And so I would appreciate hearing at a future meeting from my colleagues on the task force who are Orphans Court judges or other task force members from other counties the benefits of having two separate courts because I've only lived in a county that just has, and I'm young, that just has one. So I'm just curious if we could have a discussion of some of the benefits because it's a new thing for me because all of our stuff is handled by the Circuit Court in Montgomery County.
Mr. Chair.
Yep.
Okay, I just wanted to ask Joe a quick question. If we have the answer, if we're going to get into it more later, I'm fine with that. And that is with respect to Orphans Court, where there is a three panel judges, and where there in the text we have jurisdiction over guardianship of the person of a minor could be decided by the presiding judge of the Orphans Court. Does that still apply where you have a three panel, perhaps you have two who are not members of the bar, one is member of the bar, so that one that's member of the bar is essentially making the final, if it's a final decision, I don't know if it's final or not, but making the decision in that particular instance without necessarily the input from the other two judges?
Well, that's how I read that, but I haven't done any further research on that provision, and I don't know if others on the task force with experience might be able to confirm that, but that's the way I read it, Delegate.
Okay, thank you. That's how I read it. I just wanted to confirm. Thank you.
Yes, ma'am.
And then two, see, we have Judge Fisher, then we have Jonathan who can follow up after. Judge Fisher.
Thank you. I just wanted to clarify, Joe, just, I think some of what you were saying about the jurisdiction is appropriate, but you said, we handle contested wills. The Orphans Courts, especially, I'm obviously in Baltimore County. I've been on the bench for going on 12 years. We oversee all of probate. So we do, we have many hearings every day. We handle personal representative removals, exceptions to accountings, counsel fees, personal representative commissions, status conferences, show cause orders, contempts when people are in violation, occasionally incarceration when people have stolen money and refuse to turn it back. It's a lot more expansive, and I don't really want to go into all of the things that we do. I will say in Baltimore County, we have chosen not to exercise jurisdiction over the person of a minor. We do have a lot of guardianships of the property of minors. I know in Prince George's County, they do exercise jurisdiction over the minor's person. So I'm not sure if Judge Groves wants to weigh in. And Delegate Kaufman, I'd be happy to tell you how wonderful I think it is to have a separate orphans court in Baltimore County. And I think our circuit court judges are in complete agreement and consistently tell me they don't want it and they're glad that they don't have it because the law has gotten really complicated and it's really a specialty kind of area of law. There's some extremely difficult laws that have passed thanks to John Lasley, the augmented estate, and other such laws that have passed that are extremely complicated. And I know when that kind of case, an augmented estate case, which is about electing against a will for a spouse, went to the circuit court, the first thing the circuit court judge did was to call me and say, "What is this? I have no idea." And so I know in Baltimore County, most of the judges I've spoken to, of course not all, believe that fiduciary matters, especially the probate matters, are better handled by judges who have expertise and knowledge in that specific area of the law. I think in Montgomery County, there's always been some concerns I've heard from practitioners that there's 26 judges and some of them know probate law really well and some of them don't. And you're never exactly sure what you're going to get. So I think that's one reason why having a specialty fiduciary or probate court in some jurisdictions has really worked well. So thank you.
Judge Fisher, yes, I was just quoting the statute and I'm wondering, Is that in the Maryland rules? I mean, is it, all the things that you do, which
I mean,
I
it's
knew.
basically the majority of the estates and trust article with respect, except for things involving trusts and guardianships over disabled adults. Pretty much all of that is within the jurisdictions of the Orphans Court. From the opening of an estate, we oversee. Judicial probate is appointing a personal representative when it's not simpler, someone's not named in a will, or there's different members of different classes or the same class who all want to be personal representative. And then all the way through the final accountings in an estate. And if there's
Mhm.
misconduct by the personal representative during it, if people don't believe that the accounts that are being filed with the Register of Wills, which we sign off on all of the accounts, all of the petitions for commissions and attorney's fees. When I'm sitting, I probably sign between 20 and 40 pieces of paper a day, petition, accountings, and things of that nature. I mean, we're a particularly busy court, and we have
Does-
hearings.
Does that come under the definition of judicial probate? I don't know.
Judicial probate is just basically appointing a personal representative in a contested manner, or determining whether or not initially the will is available to be probated, should be probated. So those are, judicial probate is just like a very small fraction of what we do.
Okay,
I mean, I
well,
can get you a list of all the petitions that we hear, if
Yeah.
that would be helpful moving forward. I mean, there's also petitions that are, and then we have caveats, which are challenges to the will, where you have handwriting experts and you have mental capacity and you have undue influence and a number of other factors which might make a will invalid under the law. So it's a lot more complicated than
Okay.
here. I mean, I think that the third thing that you had in your thing was all orders involving, I don't have it right in front of me.
Yes,
All orders
yes.
involving basically anything else having to do with the probate of an estate. So basically start to finish, which, ideally will take a year or less, but can be several years. We have a lot of asbestos in Baltimore County cases that can be reopened. I just saw one from the 1990s the other day. So, we have thousands of estates. So it's a lot more complicated. If you look at the Estates and Trusts article and you see how lengthy that is, the majority of that is stuff that's coming before us.
Okay. All right. I'm going to turn it over to Jonathan, and then Byron, then Mary. And and real quick before you go, Jonathan, I know we have not necessarily tapped all the way into examining the jurisdiction portions of the in the agenda yet. It kind of seems like we're diving into it now. It's transitioning in, so just take that under consideration.
Will do. Thank you, sir. So I just quickly wanted to respond to Delegate Kaufman's question. It's important to note that when the Circuit Court in Montgomery County is acting as the Orphans Court, they are in fact a separate court. So they have to go through some of the same procedures and so forth that an Orphans Court judge, and I'm sure Judge McQueen can speak to this much better than I can. But it's not as the Circuit Court, they're acting as the Orphans Court. So you still have this bifurcated arrangement.
All right. Thank you, Jonathan. Byron.
Yeah, thank you, Mr. Chairman. Delegate Kaufman, I think you sort of asked the $64,000 question, where you're going to find, I think, a lot of disagreement or a lot of varying perspectives on the status quo that we have, the benefits of whether it's attorney courts and whether it's a circuit court. I can tell you my experience in Howard County, having transferred just a few years ago over from having an elected court to the circuit court, has been a night and day benefit to the public. I also just want to say on the jurisdictional issue, most probate, and this is for everyone who is watching and for members here who don't deal with this stuff every day, most probate is handled administratively by the registers of wills. Most probate never goes in front of a court, okay? That was something that was done by the legislature purposefully back in 1970 to make our probate process less of a judicial oriented process and more of an administrative process. So almost all small estates, for example, that's estates up to $50,000. The vast majority of them only ever come before the Register of Wills. We also deal with something called ancillary probate. That never goes before the court either. Also, larger estates that go through a process called modified administration very rarely go before the court. So it's something like 2/3 of estates, probate estates in Maryland, never go before a court. They're dealt with administratively in a less kind of adversarial kind of fashion. The last thing I want to note, and I think this might be helpful because this question of guardianships keeps coming up, just to put in perspective the number of guardianships that are conducted through the registers and the orphans courts versus the circuit courts. For the last full year that I have data, and this is from all 24 clerks and all 24 registers, this was fiscal 2019, the circuit court handled 4,007 guardianships. The orphans courts did 153. And in this most recent fiscal year, it was only 111. So guardianships through the registers and orphans courts are extremely rare. We just don't do a whole lot of them. So I just wanted to clarify that since we keep coming back to guardianships. Thank you.
Thank you, Byron. And Mary?
Thank you, Mr. Chair. I'm coming from a perspective that I was on orphans court before I then filed to run for Register of Wills. And my experience has been that the orphans court, which if you look at the jurisdictions, there's 63 elected judges, and of those 19 are attorneys, the rest are lay people with varying degrees of experience or lack of education. We don't even know. It states you don't even have to have a high school degree. And the fact is that there's very, very little training, that I had major issues coming then to become a orphans court judge, that it just wasn't doable. Simply because of the lack of knowledge. You're not a lawyer that understands the law. You may never have been in a courtroom before. The other thing also is I have spoken with the circuit court judges here. They are in support of that. The circuit court should handle orphan court matters. And I've also spoken to the Frederick County Bar Association that handles estates, and they've also indicated the same thing. So when you take a look at that, I've looked at both sides here, both as an orphans court judge and also now as a Register of Wills. And I know it's no secret, but I am in the process of trying to get a referendum in Frederick County to have orphans court then fall under circuit court. Thank you.
All right, thank you. Judge is cutting everything off.
McQueen.
Judge McQueen, yes.
Yeah.
There we go.
I just wanted to add that the 3 circuit courts that sit as the orphans court also handle how they do that differently. Montgomery County, it rotates. My understanding of Howard and Harford are that they have a judge who, for at least a period of time, one judge who handles all of the orphans courts matters. So the circuit courts who sit as orphan courts don't handle things the same across the board.
Thank you, Judge McQueen. Laura?
I don't know if I can speak, but as a attorney in Howard County, we do have primarily one judge who sits as the orphans court, and then we have some other judges who fill in as needed. But so it is, like Judge McQueen said, different in the different counties, and Howard County definitely handles it differently than Montgomery County.
Okay, thank you. Judge Groves, did you have anything you want to add about Prince George's?
I'm sorry, I just saw that I was on mute. Yes, with respect to Prince George's County has been handling guardianship of the minor as well as the property of the person and the property of the minor since before I got on the bench in 2006. I think we are the only jurisdiction in the state that deals with the guardianship of the person. So I wouldn't be able to address Delegate Bartlett's question regarding whether there's just one attorney judge sitting with two other lay judges, because I don't think that those jurisdictions take those matters. I did also want to address the training issue. Chief Judge Bell put out an order in 2003 to create the Conference of Orphans Court Judges. And in that order, in his subsequent order of 2010, to require orientation of new judges coming on to the bench, he made reference to classes being offered by the Judicial College since 1999 for orphans court judges. So I'm sorry to hear that there are some judges who have not taken advantage of the classes offered by the Judicial College, or who are not satisfied with the classes offered by the Judicial College since 1999. But if they do have any issues, they can feel free. The people who work at the Judicial College have often asked for suggestions for any classes or courses for any judges who are not satisfied with what's been offered. But there has been continuing education since 1999 and orientation for new judges since 2010.
Okay, thank you, Judge Groves. All right, so I know we've been kind of going through a lot of different pieces, tapping into section 5 of our agenda, which is examining the jurisdictions. We've kind of already stepped into it, and so I think we should just go ahead and continue that conversation in respects to the fiduciary matters. One, in orphans court jurisdictions and jurisdictions that require orphans court judges to be attorneys: Baltimore City, Baltimore County, and Prince George's County, and in jurisdictions where circuit court judges sit as orphan court judges for Hartford, Howard, and Montgomery counties. In our agenda, we have Jonathan, Laura, and Kelly from MSBA to discuss from MSBA's perspective. We have Byron and Mary from the Register of Wills, and we also have Mary Jo from DLS. And so we were giving each group who will be presenting at least 10 minutes to speak on both agenda items, and then open up for questions and discussions for everyone so that we can at least get all of our issues heard on these particular topics. So do you guys want to jumpstart everything, Jonathan?
Sure. Thank you, Mr. Chairman. I think something we've heard here is we have this system of two courts hearing what in many instances can be very similar matters, often the same matter, and we'll talk more about those procedures in future meetings. But for example, the Orphans Court has jurisdiction over matters occurring under a will, whereas the Circuit Court has jurisdiction over trusts. A very common estate planning technique is the use of a revocable living trust. You've probably heard that there are ads for them on TV these days. So that usually involves a will and a trust. If there are disputes about both, and Kelly's better able to walk through these procedures than I am, you're starting at least in two courts, and you have to work to get the same dispute merged into one place. In the materials you've received that have been circulated for this meeting, you can see that the vast majority of states don't do it that way. There is one court of general jurisdiction over all fiduciary matters, whether that be what originally started life as the probate court, or whether that's their equivalent of the circuit court, that varies. But most of them have a one-stop shop. And so what I'm hoping we can discuss here is the inefficiencies inherent with that just bifurcated jurisdiction we're starting off with, before we even get into other issues that may be occasioned by procedures involved in moving things between the courts and the training issues and qualification issues that have been touched on tonight. So with that, I'd like Kelly to sort of walk through the experience of dealing with same or similar matters with the same parties in multiple courts.
Sure, I'd be happy to. And interestingly, despite the fact that we have several different ways that counties approach having an orphans court, whether it be an independent court, whether it be a part of a circuit court, or whether there be all lawyer judges, some lawyer judges, no lawyer judges, the inefficiencies appear to persist. And if you look at from the perspective that John was talking about, where you have a revocable trust and a will that pours into that trust, they were likely created at the same time, likely by the same practitioner, and likely suffer from the same issues when validity is contested. And so to Judge Fisher's point, that there are often complex issues associated with whether it was signed correctly, whether it was the result of undue influence, whether the individual that made it, the testator, settler, same person, has capacity. The facts that underlie all of those are the same, but yet you will be forced to file a challenge to a will in an orphans court. You can do it nowhere else, and you must do it 6 months from the date that the personal representative is appointed. Conversely, if you're challenging the validity of a trust, the time metrics are different, 6 months to a year, depending on if certain notices were given, and you're filing in the circuit court. And that happens across the board. And so if you then are trying to figure out a way to have these matters consolidated, you need to, in any of the orphans court, transmit the case up to the circuit court and then consolidate them together so that they can be heard by the same circuit court judge. And to Judge Fisher's point, because there is tremendous benefit to having expertise, sometimes when you do that, you get someone who is not an expert in those areas. And so you have a judge that really would prefer never to hear the word trust or estate adjudicating these matters. Similarly, we have issues associated with appeals, which do not persist across all of the various orphans court structures. When you have a combined circuit and orphans court like Hartford, Howard, and Montgomery, you cannot take a de novo appeal, but in every other orphans court you can. So you're effectively getting a do-over in a circuit court case, which, like, frankly, in my opinion, undermines the work of the orphans court judges. And I think practitioners really abuse it by taking their chance to really see how the case would play out, see how their facts are received, and then make tweaks because they get a complete do-over. So looking at these issues, it caused us on the Section Council to really think about how can we take the wonderful parts of the orphans court with all the expertise that we have with, Judge Groves and Judge Fisher, and look at how that expertise can be employed in a model that is, one, more consistent with what the rest of the country is doing, and two, disposes of these inefficiency issues that, as I said, still persist in the model that is the combined, the orphans court combined with the circuit court so that you have the circuit court judges sitting.
Thank you. Byron? You had a question?
Thank you, Mr. Chairman. I just had a quick question for you, Kelly. This question of the de novo aspect of this I've heard this talked about for a long time. And I remember, I think it may have been 10 years ago or so, there was a suggestion to do away with the de novo appeal aspect of the orphans courts. And my recollection at the time was that the bar was vehemently opposed to that because if memory serves, the argument was, well, if we don't have a de novo appeal and it's appeal on the record, every single hearing we ever have before an orphans court, we have to prepare and we have to make sure the record is as perfected as possible, even if it's as simple as a judicial probate hearing where there's no contest. Can you just comment on that? Because that was my recollection in the past was that that was not something that was supported by the bar.
I can't comment on it from what the bar as a whole thinks. I can comment on it from the perspective of a practitioner that's seen it in use. I mean, first and foremost, I think attorneys should go in prepared for any hearing. But when you think about the opportunity to do it again effectively, you're really costing the individuals who are asking you to represent them twice. You're costing the other parties twice. You're paying two judges or more to do the same things, courts to hear the same things. So it seems really inefficient. It seems to me that part of the concern was we have situations where we have non-lawyer judges hearing matters. And so I can understand why it exists, especially in those counties where you may have non-lawyers making the best decision that they know how to make, but maybe without all of the expertise they would need to make a correct decision. And so we give the opportunity to litigants to do it again. But if we ameliorated that issue and had judges who were well suited to hear the matters and the lawyers knew that and they came in prepared, it'd be like any other circuit court matter. You better be prepared and create your record, because if you want to appeal it, that's what you're left with.
Okay. Well, thank you, Kelly. I don't disagree with you. I just wanted to throw that out there. Thank you.
I appreciate it.
Judge Fisher? Judge Fisher?
Sorry. In Baltimore County, we have maybe a handful of de novo appeals a year. And we last year had almost 2,500 scheduled hearings. And I can think of 3 that I'm aware of in the past year. I'm sure I can get the statistics from our register this week if those aren't available through the judiciary. But we really have very few of them. So I haven't seen that to be a problem. And most of the ones that I can remember, I mostly look at the ones that I've heard. None of them, the circuit court judges have all ruled the same way. So I know that it might be a problem in the handful of times or maybe in other jurisdictions, but speaking for Baltimore County, it's really not something we see very often. So, and I think that, in the smaller jurisdictions, they have a much smaller caseload. So I'm not sure that they have as many either. So I just wanted to give the perspective for the people who aren't on the day-to-day familiar with the role and what's going on in the orphans courts to get an idea of, maybe 5 or 6 we had last year out of 2,500 scheduled hearings.
All right, thank you, Jonathan. And just a quick, we're at 6:44 and the meeting is set to go, what is it, it's an hour meeting? Or we can try to keep it going as long as we can, but it's 6:44. So Jonathan, then Judge.
Thank you, Mr. Chairman. I'm hoping what I have to say may streamline things a little bit. We've got a whole meeting scheduled, our next meeting, I think, to go through the procedures that'll involve things like transmissions of issues and de novo appeals. What I'm hoping we can focus on today is the fact of, regardless of what those procedures are, you've got 2 courts covering the same or similar matters with separate jurisdiction. And that's, as I said, and so you've got, the expertise often, as Judge Fisher pointed out, in the orphans court, people who are hearing fiduciary matters day in and day out. And then you go over to do trusts, which are very similar issues, over in the circuit court, and depending on the draw, you may or may not get somebody hearing that who's familiar with those issues. And the same thing goes for guardianships, moving one way or the other, depending. In Prince George's, for example, for the minor, you're going to go to the orphans court, but for everybody else, you're going to go to the circuit court. And the fact that we have this bifurcated system spreads out the expertise and doesn't, just don't in a very complicated, constantly evolving area of the law, it would be much more efficient, in my view, to have a one-stop shop.
And just to add to that, John, an example of where there's a gap and overlap is the elective share law, which I know is complex, but it is also important because of the way people do their planning now, and that it's not just through a will, but we have these complex trust structures, and we have a situation where the Orphans Court is charged with adjudicating the issues associated with the elective share and needs to allow parties to get after assets that are outside of its jurisdiction. So then litigants are forced to then go to the circuit court to try and get the assets that and information about those assets related to non-probate items. So it's just, there are examples of this throughout the fiduciary landscape, where if we had a combined jurisdiction that handled these matters cohesively, we wouldn't have these issues and gaps.
All right, thank you. Judge Groves?
Since Kelly mentioned the elective share, I did want to thank Mr. Lasley for giving classes for the Orphans Court judges on the elective share. We've actually had 2 classes at the Judicial College. So thank you, Jonathan, for that.
All right, thank you. All right, do we have any other questions or any comments on this particular issue before we move forward on the next portion of the agenda?
It looks like Byron has his hand up.
Byron? Okay, thank you,
Yeah,
Byron.
Mr. Chairman, just very briefly, I just wanted to add, we're talking a lot about issues related to issues that play out in the orphans courts and kind of related issues in the circuit courts. I do just want to add, there are also, I would say, sort of non-fiduciary related issues that touch on the death of a decedent that the orphans courts also don't have any jurisdiction over. For example, bodily remains, they have no jurisdiction over that. Cemetery plots are not probate assets. The orphans courts do not have we have a lot of issues with people sort of staying in in a decedent's home. Orphans courts cannot evict people. So with all of that, there are a lot of related, also like replevant actions. If someone's holding on to property that belonged to the estate, that should be resolved in district court, not in the orphans court or circuit court. So, I agree with the spirit of where this conversation is going, in the sense that having one court that could handle basically everything related to the death of a decedent, their assets, their body, their cemetery plot, regaining assets that have been taken away from them, whatever it may be. I think that I agree with the spirit that it would be helpful, because we do see with the registers of wills that kind of frustration. And I've sat in with our circuit court judge when he presides, and oftentimes there is a related guardianship issue, and he has to kindly advise them to go talk to an attorney and proceed elsewhere. Or if it's a district court matter, point them in that direction. So I just want to note that there are a lot of issues, not just other fiduciary issues. There are an awful lot of issues related to the death of a decedent, where I do think that having a one-stop shop, so to speak, court would make a lot of sense. I think we may find ourselves differing over what that looks like, but I think that we may have some agreement that it is an issue that we should try to resolve. Thank you.
And thank you, Byron. And that takes us into comparing the jurisdictions of probate courts in other states, because obviously other states are doing this one way over the other. And so I don't know, Joe, if you want to tap in, or John, if you want to
Chair,
tap in.
maybe now would be a good time to have Mary Jo give her presentation, the department's research. She just has some quick slides that might be helpful here.
Okay, so Mary Jo's doing that one. All right, thank you, Mary Jo.
Mary Jo, I think you're on mute.
She may want to share her screen to show the information. I was reading through it. It's a lot of good details in there. She may want to share with folks.
She might be having some issues. Does somebody else want to get? Okay, she's having issues. Let me chat with her, and if somebody else wants to get started here, and then we'll have her come back in a minute. Let me see what's wrong with her Zoom.
Okay, Jonathan or Joe, do you guys want to address any of that at all, or you guys want to continue the discussion that we were having?
Joe, do you have access to the slides? I don't have them on this. I have them on a different device.
Yeah, I can bring them up. Let's see.
Hey, Joe.
Yes.
I figured out my problem, so I am good to go if that's okay with everyone else.
Okay, Mary Jo.
For the chairman, yeah.
Yep.
Thank you. Sorry, guys. Someone needs to let me share. It says I can't do it. Maybe Jesus, can you do that?
Oh.
Jesus, are you there?
I could
Mary
bring
Jo,
it
you
up.
can.
Sure,
Mary Jo, you
bring it
can
up.
present now.
that would be great. Can you bring up the can you bring up the PowerPoint for the states?
Yes.
Okay.
You see that? You want to start?
Yeah, and I'm just going to make this really short and sweet because we've talked about a lot of this, but I want to get into a few more things with the spreadsheet in just a minute. As everyone has noted, almost all the courts in the United States, or at least 75% of them, do not have a separate probate court. Starting in the 60s and 70s into the 80s, the little itty-bitty courts that existed in many places. For example, Baltimore and the, up until 1980 had 6 different courts that were handling things that were eventually consolidated into what we now know as circuit courts. And in 71 in Maryland, we began another consolidation, moving all the little itty bitty municipal courts into what we all now know as district courts. So this is some process that has been going on across the nation. And sometimes it includes and sometimes it doesn't include separate probate courts. And I think a large part is that in Maryland, the probate courts are really in kind of a separate entity of their own. They're not as well embraced by the Maryland judiciary. So, for example, if you look at many of the judiciary reports in Maryland, they never include any orphans court data. If you need that, you have to go to our good friends at the Register of Wills. Jesus, can you put it up to the next slide? Oh, one more point before I go away. I did a little bit of analysis. 60% of the population in the state of Maryland has a judicial matter heard by an attorney, either a circuit court attorney, or in the case of Baltimore City, Prince George's, or God help me what the third one is. Jesus, can you put it up to the previous slide, please?
Oh, this is me, Joe. I'm doing this. Is this?
Yeah.
It's Baltimore County.
Baltimore County, thank you. Oh, I'm really sorry, Judge Fisher. I also wanted to point out that Montgomery County has been doing this since almost when I was born in 1964. So, how they handle their rotation issues and stuff, there's been a while to kind of work on that. Hartford is closer. They've been doing this for, about 40, 50 years. And Howard is the newcomer. And I think one of the things that would be helpful to get to you guys is the legislative and policy note about moving that court from a circuit court, from an orphans court to a district court. Next slide, please.
Okay. Do you want to look at the national?
Yeah, I wanted to do the
Joe?
national. Does anyone have
Okay.
any questions on the Maryland state stuff? I think
Okay, I didn't have this up at first.
pretty clear. Okay. Again, nationally, almost all the states basically fall a court of general jurisdictions. What's interesting when you look at the places that have separate probate courts, you will notice like Connecticut, Georgia, maybe Maine, depending on how you count, Michigan, New York, Rhode Island, South Carolina, we're all part of the original 13 colonies. And this is the kind of the way things were done. Maryland's changed it back and forth a couple times, but they have called them from the time of beginning the people's courts because they're not judges on the courts, and they're by statute designed to be represented by quote unquote the people. But in those intervening years, law has gotten a lot more complicated. Jesus, can you pull up the spreadsheet?
Okay. This is Joe. I'm doing this. Mary Jo.
Oh,
That's okay, but I got it.
Okay, cool.
Yeah. I'll make this bigger. Can you see it? Can you
I
see
hear
it?
bigger.
Bigger? What do you want to show? I can't get it on the screen if it's
Yeah,
bigger.
thanks. No, what I wanted to point out was there are some states that do handle trusts within individual probate courts. So, for example, Connecticut, Maine, New York, and 1, 2, 3. Who might I say? It's hard to say.
Michigan.
Michigan, thank you. All have those two major issues that you guys have been talking about, whether it's a will or whether it's an estate. Those are in the probate courts in a few of the states. What a lot of states have done, Jeff, you can go down a little bit further.
Yeah.
Is they have created a special division within their courts of general jurisdiction to handle estates and trusts. They look to me a lot like how family law is handled in circuit court, that they have a magistrate system where the magistrates go through, they meet with the families, they do all the drafting, the documents, they do the hearing. When they're done, it's a circuit court judge who reviews and signs off on it. So rather than necessarily putting everything in the hands of circuit court, one of the options might be to develop kind of a estates and trust magistrate system, which looks like my research has shown that many of the states have done that. So thank you all. I know we have like a minute left.
Yeah, thank you. Thank you so much, Mary. It's definitely 6:59, and we're trying to try to get through as much of this information as possible for everyone on the committee to be able to address it and for the public to be able to hear it as well. Holly, I texted the group trying to get more details for our next.
I just responded, Chair Charles. So the next meeting is November 3rd, and we're going to be discussing the efficiency of procedures for adjudicating fiduciary matters, contested and uncontested, in the orphans courts and circuit courts. And then hopefully we've requested some data from the Maryland Judiciary related to those number of appeals and de novo cases. Also layperson's appeals versus attorney appeals in the different courts, categories of courts. And then we also have requested some data, I think, from the Conference of the Orphans Court Judges. So we're hoping to cover those two issues.
Okay, thank you so much. Kelly, so you have a question.
Yeah, just quickly, Holly, to the list of information we requested, have we also sought the number of issues transmitted by each orphans court?
They can't get that.
I think that's important
I don't think they
because
can distinguish, they'd have to go through it manually to distinguish between transmission of fact and de novo.
as
they
long as
haven't-
they're capturing the transmissions as a part of whether, I mean, they are different, but as long as they're capturing them, I think that's important. If we overlook transmission of issues, we're missing a huge swath of inefficiency issues and we will want that data.
Kelly, thank you for raising that. We had a long list that went out to them. That was just touching on a few of the big points that have come up even at this meeting. But yes, we've talked to Maryland Judiciary and
Ms. Vandergriff, we can't hear you.
can you hear me now?
Yeah, I can hear her pretty good, Delegate Kaufman. It may be your earphones.
Sorry, but yeah, I have a long list, but this goes to all the members. If you have more data or ideas that you'd like, please send it to us so that Joe and I can get it to the right group and see if the numbers are there or if it's something that we can attain for you. Hopefully this number, the transmission of facts and the appeals, we'll be able to at least get something. I do think they're grouped together based on our conversation, but again, that'll all be at the next meeting on November 3rd. Hopefully, assuming they have the time to gather everything.
All right, thank you so much. Mary Jo, then Judge Groves.
Not muted, yay. Kelly, to help us out with the request for the judiciary, when you fill out, the court information sheet, to send the case in, what boxes are you checking off?
You file it in the orphans court to seek transmit issues, and then they certify what's being transmitted to the circuit court.
So might be better if maybe we got this information for Register of Wills if we can't get it from the judiciary.
That I defer to the Register of Wills on.
Fair enough. Thanks.
All right, Judge Groves.
I just wanted to say that we've made a request. We, as the Conference of Orphans Court Judges, have made a request of the judges for that information. So they've already started gathering their appeals numbers, and we've also asked for the transmission of issues. And I just wanted to say that Kelly was a part of that first class teaching the Orphans Court Judges about the augmented estate. So thank you to Kelly too.
You're very welcome.
Byron, I saw your hand went up and came back down fairly fast. So.
I just had one really quick last note. Just Mary Jo you did a great job of summarizing the approach that every other state uses. I just wanted to note one other interesting little fact about Maryland and how we sort of stand out in the rest of the country. Not only are we in the minority in having a specialty court, we're also in the minority of not requiring our judges be lawyers, and we are the only state in the country that has a 3-judge panel. Every other state in the country has 1 judge presiding over these matters. We're the only one that uses 3. So all of that to put in perspective as we move forward with our deliberations. Thank you.
Okay, thank you so much. And I think we don't have any more comments because I don't see anyone else's hands raised. So I'm going to conclude and just let you know next week, next Monday at 6 o'clock, we will be meeting again to go through the rest of the issues at hand. And hopefully everybody comes prepared, ready to go so we can continue to move forward. And I just want to thank you all for your diligence on this issue. And thank you for the community who is participating and watching. And we will move forward in the best interest of all Marylanders across the state. So thank you guys, and I will see you next week. And Judge Groves, I emailed you also. If you can please follow up with the email. Thank you.
Thank you, Senator Charles.
All right. Meeting is adjourned.